Okay, we will start now. Good morning, one and all present over here. Today we are here for webinar on IPR awareness program by government officials, Indian patent officer. Respected principal sir, Pillai HOC College of Engineering, then respected chairman IIC, Dr. R.C. Prasad sir, then all faculty members and students present over here. We are here for IPR awareness program, and I welcome on behalf of Hendre HOC College of Engineering and Technology, Mr. Anshul Verma and Pratik Hendre. Let me introduce our today's guest speakers. We have Anshul Sharma, who is working as a Group Gazzeted Class 1 officer under Ministry of Commerce and Industry at Indian Patent Office. He is having very vast experience in intellectual property rights, and since last 6 to 7 years he is working in this field. Then we have other speaker, Mr. Pratik Hendre. He is also working as a Group A Gazetted Class 1 officer under Ministry of Commerce and Industry at the Indian Patent Office. He is also well expert in patents and design since last 6 years, and recently he has been appointed as the appointed at this post after achieving 3rd rank at Indian national level exam, which is equivalent to UPSC exam. I welcome you, Sir, Mr. Pratik and Mr. Anshul Verma. So we can begin, and we have here, sir, students and faculty members of Pillai HOC College of Engineering and Technology. Over to you.
Good morning, everyone. Am I audible?
Yes, sir. Yes, sir.
This slide is visible to you?
Yeah, visible.
Is this next slide is changing?
Yeah.
Okay. So today we are here for webinar on intellectual property awareness. So this is new mission or program started by Government of India and Patent Office on the occasion of 75th anniversary of independence. So the target is to make all the students, faculty to aware regarding intellectual properties. So we'll start with this. In this slide, this is a logo of IP, Intellectual Property India. In this on eye, this symbol is showing as a brain. Brain is a gift of God, and it is everyone having their brain, different brain capacity. The output or any new idea, new invention, new creation coming from your brain, that property is called intellectual property. As you all are aware that other types of property like home, flat, land, car, these are one type of property, but the property or output comes from your brain, that's called intellectual property. As per Global Innovation Index of WIPO, that is World Intellectual Property Organization, India is on 48th rank in 2020. Why India is on 40th rank and not in first 10? It is due to the lack of awareness about intellectual properties. India having the 7th largest country, also in population, India in first or second number, but still India having very vast number of intellectual people, but due to the lack of awareness, India is not in first 10. So our target is to win first 10 within coming years. As per so what are the intellectual properties? Intellectual properties are like patents, design, trademarks, geographical indication, copyrights. These are the main IPs. So intellectual property rights, the concept or rights or idea coming from your brain, combining with available resources and own efforts or labor skill. The combination of all these three, the output or final output of this is a one type of property, that is a intellectual property. Assume students, engineering students wants to make their final year projects. So the idea of that project and the framework of that project comes from your brain. That is a brain idea. Then available resources, the guidance from your teacher, the seniors, internet, standard books, that is available resources, and your own efforts, that is software skills or hardware skills or the other all types of efforts. If we combine all this together, the final result is your black book or final year project report. So report with black book. This property is also type. Example is the property. That property is called intellectual property. So what are the importance and significance of this IP? You can protect your own rights for your own self. So without your permission, no one can use that. You can exclude others from using that. If anyone is using your own rights without your permission, then you have that much rights given as per IP Rights Act. So you can exclude others to not to use that. Also, you can utilize your rights for commercial earning. So this is the importance and significance of these IP rights. How you can utilize or commercialize these IP rights? You can use for your own self. You can start manufacturing, production, or you can keep for your own self only. Else, you can give license or assign your rights to someone else. By giving license and assigning your rights to some other any other person who are interested in that field or in that product. Instead of that, you will get in exchange of that you will get some money. Other option is franchising. Example is McDonald. The owner of McDonald is not going everywhere and starting his branch. He giving his franchisee to the different people who are interested in food industry. And the last type of utilization is merchandising. Example is Disney. So from these all four options, you can earn money from your IP rights. So if you having IP rights with you, so in that case there is two different approaches. That is one is common person approach and businessman approach. In common person approach is that you are feeling pride that yes, I have received patent or trademark or copyright. You are showing in academics, some are getting promotion on that basis, or some are getting hike in their job, or some just putting the printout, taking printout and putting on wall that yes, this is the I have pride only, or who are keeping as a WhatsApp status, Facebook photo, that's it. But they are not commercializing that. This is common person perspective. What is businessman is doing? Businessman is doing, if he received a patent or any IP rights, he will start commercialize that product. As he start commercializing that product, making a brand value of that product. Once that product get a brand value, he will start earning more and more money from that. Once he received more money, he will again invest in new invention or new IP rights. Again, he will get IP rights. Again, he will commercialize that product. Then again, making a brand value. Again, earning and investing. That cycle will continue. So this is a very good approach by businessman perspective. So it is a more recommended that you should think like a businessman if you have IP rights with you. Now we'll start with patents. Patents is an exclusive rights to given inventor for making, using, exercising, vending his own invention or product. It is a sovereign right given by sovereign state. In our country, government of India is the only sovereign authority who is giving these rights. in patents is given for invention for limited time of period. The time period is 20 years, but you are getting monopoly or full rights about your product, about your invention. But in exchange, you require to disclose about your invention in a complete specification. So the complete specification should be such that any average skilled person in the art can reproduce that invention after the validity or term of patents. Means if valid a term of patents 20 years, after 20 years your invention goes to public domain. So in the after 20 years, any person who is in average skill in the art, same subject matter, if anyone having similar knowledge about that subject matter, he can reproduce just by reading your disclosure. So you require to disclose your specification such that it can be reproduced by any average skilled person in the art. This is owner's qualified right of using invention. He can exclude others from using his own invention. These are some of the famous inventions. Nano car. Tata provided opportunity to middle class people for getting four-wheeler car in the budget of two-wheeler bike only. This is a very good invention. Then hepatitis vaccine, Jaipur food. These are very well-known and very good examples invented by Indian persons. So these are some of next inventions. Inventions are these zigzag like the baby shower cap is one of the very good example. Here inventor uses his skills as छोटे बच्चों को जब नहलाते हैं तो आंख में पानी जाता है, doesn't feel comfortable. So the inventor uses his creative mind and he made a cap like structure but in zigzag manner, and this is also good invention. Then I think some of the faculties is sitting in auditorium and they have projected by using projector. So this example is a wristband projector. This wristband projector can project the display on the palm or hand itself. Next is this is a digitized era. In this, everyone is using debit cards, credit cards. So to swapping or use that, to instead of using that bulky machine, this is a very cheap, small chip like structure, and it can be connected to your own phone or the receiver's phone. And just by swapping, this is my microchip structure and very good invention. Then drone delivery system. Drone is not only using for camera or videography purposes. Nowadays, some companies started to use this drone system for goods delivery purposes. Then this is a foldable hanger. This is a compact in size and very lightweight. So it can be carried from one place to another easily. As all knowing that the standard traditional hanger structure, but these are compact ones. So this is also one type of invention. Then this shoes. This shoes is made such a way that there are some internal sensors are placed. So as the person starts walking, that sensors gets activated and this logo start blinking. This is same example as छोटे बच्चों के जो musical shoes होते हैं, and both are the examples of invention. This cap with light. Then this is auto intelligent adjustable manicure. This manicure are made such a way that it can fit in any size and any shape. There are internal settings there. So for different sizes or different types of clothes that doesn't require different manicures. This single manicure is useful for many types of clothes and sizes also. This purse which embedded with fan cooling system. So the ladies can switch on or off that fan whenever they need it. So this is also a good example of invention. This person name is George Alfred Penny. He received India's first patent in 1856. So he was civil engineer and his invention was an efficient pankha pulling machine. So India also having very long history about patent because he received patent in 1856. Before the rise of Mangal Pandey, 1857, he received patent in India. So now you will think that he was civil engineer, he had made a very big research and then only he received patent. No, every time such case is not happening because if you have any scientific knowledge or scientific research and then you are applying for patent, that is a well and good thing. But if you have any solution to a particular problem, that's also can be an invention. You can see in next slide. This is a simple paperclip, and this paperclip received patent in 1919 at the time of First World War. This paperclip was filed for patent. So invention can be a small thing or big thing, a small paperclip, small needle to a CT scan machine to time machine or any robotic machine. It can be anything. This is the example of famous celebrity Michael Jackson. He received patent in 1993 from USA. He made anti-gravity illusion shoes for his songs, dancing songs. He received patent and he was himself was the inventor of that shoes. There are some other examples like nowadays due to healthcare sector is on many things required in health sector. So 3D models for surgeries. So the surgeon can practice on 3D model. So they get comfortable while operating the patient. Then AI robot system, which are useful in heart treatments or patient treatments. Then cloud-based systems, which are very helpful in data transmission and collection purposes. Then hydraulic stretchers, video laryngoscope. These are also some of the very well-known examples. Now we'll go to next IP, that is a design. Design is ornamental or aesthetic aspects of an article, and that it can be a feature like shapes, configuration, patterns, composition of lines, or combination of different colors of an article, and which can be judged solely by your eyes. If you are making the differentiation between two different designs, then that comes under design. That design pattern. For design pattern, that doesn't require any composition or constructional feature. The design pattern is given to the final design of that product. In this slide, it's showing that a car having the green leaves on that design on that car. So this is also example of design pattern. And the term for design patent is 10 years and it can be renewed for next 5 years. So total 15 years is the term for industrial design or design patent. So in market, you are seeing many different brands, mineral water bottles available, but each company having their unique design shape. Similarly, tablets or mobile, each company and each product having unique and different shapes. This mobile also having unique shape, your laptop, PC also having their different unique shape. This keychain having a different unique shape. It comes under design. The shape on design on this part, that's also comes under design. So in design, you can see these are some of the examples. This Coca-Cola bottle, they have patented under design patent for the shape of bottle. So no other company can copy the same design as Coca-Cola. Also, nowadays people are used to with this Tetra packs. So each company having their unique and different designs for these Tetra packs. Design pattern can be given to a single product like a single watch or the design on your mask or cycle, but it also can be given to a set of products. Example is sofa set, jewelry set, crockery set. So design pattern can be given to a single item or a group of or set of items. Next is trademarks. So Trademark is a sign or symbol distinguishing the goods from one enterprises to another one. These are the some of the examples where I have purposefully removed their name, but I think you all are able to guess this product. That is, this is Nike, this is Puma, McDonald's, Pizza Hut. Without mentioning their name, you are able to distinguish. These are this logo or sign belongs to this particular brand. So any sign which are able to distinguish that goods and services from one enterprise to another, that comes under trademarks. In trademarks, it can be a brand name, tagline, certification mark, sound marks, logo, or moving marks. For example, the sound or musical tone of Disney cartoon, or the roaring lion of MGM, or Britannia's musical tone as ting ting ting. Just by listening this, you can identify or understand this belongs to this product only. So that is comes under trademark. A brand name, as I have mentioned in previous slide, that is the logo and sign. But in that, this Nike, this is a brand name, and the tagline, "Just do it." For Coca-Cola, "Open happiness." So these taglines also made a big impact under trademark. Then next is the certification mark, that is BIS mark, ISO marks, that also comes under trademark. So in this trademark, these are the important points to understand. So what subject matter comes under trademark? Now, how can you identify or find these are the good trademarks or not? The good trademark should be distinctively different. It should not be deceptively similar, because in market, the some people are making a cheap product of standard good trademark products. Like example, people are making Adidas as a Abibos, Abibas, and people are buying that cheap product, and the creator of that cheap product is earning money, getting the benefits of the uh, big trademarks. Also, some of the examples: Parle-G, Regal-G, then Nike as a Nice, Nicey, Puma as a Puma. So people are getting benefits of this good trademark. So it is recommended that your trademark should not be deceptively similar, or should not be available at previously available or known to anyone. Now, how can you identify these trademarks are registered one or not? They are mentioned on any product in circle, anything are in mentioned in circle, that means that product is registered. And if just mention TM, means it is under process, it is not registration or process is not completed yet. Next, IP is copyrights. How can you identify these are copyrighted product or not? So C in circle, that means that product is copyrighted. Copyright is given to creator for his uh, uh, expression of ideas. This right is given for creator for his expression of idea. Expression of idea can be a literary or artistic, musical, dramatic, these types of works. For example, copyright is a bundle of rights, and it automatic rights. Exclusive rights given to creator for his original work. As a bundle of rights means it's a moral rights and legal rights to that creator. And automatic rights means once I compose one music song, from that time that rights belongs to me. अगर मुझे कोई poem याद आ रही है, नया सूझ रहा है, so when I express that poem to someone else or note down somewhere, from that time that rights belongs to me. So this comes under copyright. But copyright cannot protect an idea. अगर आपके माइंड में या दिमाग में एक आइडिया आ रहा है, हाँ ये म्यूजिकल टोन में बनाता हूँ, ये ऐसा कंपोजिशन बहुत अच्छा होगा, लेकिन आपके माइंड में है, आपने एक्सप्रेस ही नहीं किया, या कोई स्टोरी है, हाँ एक्स राजा था एंड सो एंड सो एंड सो एंड, बट आपने किसी को बताया नहीं, आपके माइंड में ही है वो आइडिया, और सिमिलर आइडिया किसी के दूसरे के भी माइंड में आ गया, so you can't claim that this idea in my mind firstly, then I have that right. Copyright cannot protect an idea. Those who are expressing their ideas, for them only this rights is given. Copyright is an exclusive legal rights granted to creator for expression of idea. The owner can reproduce, translate, adapt, perform, or distribute his work. Then for copyright, registration is not mandatory, but it is more recommended to get registered under copyright for better legal enforceability. Because if anyone copied your content or any work, so if you have registered one under copyright, then you are easily prove that this belongs to me. If you haven't registered under copyright, so that time all liability goes to you, the original creator, to prove that this belongs to me, this is already published or already known to common public than the who have copied. So copyright is given in this all section, that is the literary work. In literary work, it can be a newspaper, news article, blog, novel, book, story, poem. The other is painting, drawings, photographs. Anyone is in photography and have captured very good pictures of nature or scenic beauty, so he can take registered under copyright for that product. So he can, no one can copy his photos without his permission. Similarly, films, music, choreography, sculpture, these all comes under copyright. What are the terms or validity of these rights? For literary work and dramatic work, the term is lifetime of author plus 60 years after the death. Means if I am the author of any book, the rights is with me till the lifetime of me plus 60 years after my death, the rights goes to my legal hire. So these are the terms for this literary work. And the other work, like sound recording, cinematograph, films, the term is 60 years from the date of publishing. From which date it is going to publish, from that day the term starts. Broadcasters rights. Example is Kapil Sharma shows rights is with Sony TV. So Sony TV can telecast that show as per their wish, as per their choice. No other restrictions on them by any other channels to when to telecast that show or how many times. Similarly, Antakshari shows broadcasting rights is with ZTV, so they can broadcast that program as per their wish and as per their choice. No one can interfere in that rights, and no other channels also can show that show, telecast that show. Example is Antakshari show without the permission of ZTV. And the term for this broadcaster rights is 25 years. Performance rights, anyone who is a performer like actor, singer, musician, dancer, juggler, or performance at circus, the rights is with them for 50 years. Next is geographical indication. Next type is geographical indication. In geographical indication, the rights given to a group of people or organization for the product of, which having special qualities due to local environmental condition and local labor skills. For example is Nagpur oranges. So regarding this, there is a small video for geographical indication. So just go through that and I will continue after that. Is this audible? Is this video audible?
It's audible.
Okay.
चिंदी चोर के साथ घमासान के बाद अब आईपी नानी बिजी हो गई अपनी पोती की शादी की तैयारियों में। संगीत वाले दिन जब छोटू उनसे मिला तो
वाओ नानी, आप तो बिल्कुल छाए हुए हो। आपके सामने तो मधुबाला को भी कॉम्प्लेक्स हो जाए।
ओए, मस्का लगाना बंद कर। ये बता, तुझे क्या चाहिए?
नानी, आपने तो मेरा दिल ही तोड़ दिया। क्या एक प्यारा सा लाडला सा बच्चा अपने नानी को कॉम्प्लीमेंट भी नहीं दे सकता?
अच्छा चल, एक्सेप्ट किया तेरा कॉम्प्लीमेंट। अब बता, तुझे क्या चाहिए?
मुझे कुछ नहीं चाहिए, बस आपके हाथ की वो स्पेशल वाली चाय पीनी है।
बस इतनी सी बात के लिए इतना बड़ा मस्का?
मस्का नहीं नानी, आप सचमुच बहुत ही रॉकिंग लग रही हो। ये साड़ी आप पर बहुत ही अच्छी लग रही है।
अरे ये तो स्पेशल लखनवी चिकनकारी है। लखनवी चिकनकारी पूरी दुनिया में मशहूर है। ये अपनी खूबसूरत और बारीक एम्ब्रॉयडरी के काम के लिए फेमस है। लेकिन पता है इसकी सबसे बड़ी खासियत क्या है?
क्या है?
ये एक रजिस्टर्ड जीआई है।
जीआई? वो क्या होता है नानी?
जीआई का मतलब होता है जियोग्राफिकल इंडिकेशंस, हिंदी में जिसे भौगोलिक उपदर्शन कहते हैं। ये किसी समुदाय का बौद्धिक अधिकार है, वो विरासत जिन्हें प्रोटेक्ट और एनकरेज करने की बहुत आवश्यकता है। मुख्यतः इन टाइप्स में रजिस्टर्ड होती है: नेचुरल गुड्स, मैन्युफैक्चर्ड गुड्स, टेक्सटाइल्स, हैंडीक्राफ्ट्स, फूड स्टफ।
अच्छा।
चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं।
हाँ हाँ हाँ।
किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख। ये एक मधुबनी पेंटिंग है, बिहार की। और ये है हिमाचल की कांगड़ा पेंटिंग। तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने का बहुत शौक है।
अच्छा।
ये कठपुतलियाँ देख रहा है?
हाँ।
ये राजस्थान की हैं। इसी तरह छत्तीसगढ़ से बस्तर ढोकरा, आंध्र प्रदेश से तिरुपति लड्डू, असम से मूगा सिल्क, नागालैंड से नागा मिर्च और मध्य प्रदेश के बाघ प्रिंट, ये सब रजिस्टर्ड जीआईज हैं।
ओके।
ये हमारे देश की कला और संस्कृति का प्रतीक हैं। हमारे देश में हुनर और कला का इतना भंडार है कि अभी से ही 300 से ज्यादा रजिस्टर्ड जीआईज हैं।
वाह नानी।
चल अब तू चाय बनाने में मेरी मदद कर। एक बर्तन में पानी ले और उबालने के लिए रख।
यस बॉस।
पता है छोटू, तुझे मेरे हाथ की चाय इतनी पसंद क्यों है?
क्यों है नानी?
क्योंकि ये स्पेशल दार्जिलिंग की चाय है। ये देश की सबसे पहली रजिस्टर्ड जीआई है, जो 2004 में रजिस्टर्ड हुई थी।
लेकिन नानी एक बात बताओ, इन जीआई से फायदा क्या होता है?
देखो छोटू, ज्यादातर जीआईज गांव के समुदाय के होते हैं। इनसे कारीगरों, बुनकरों, किसानों की आमदनी बढ़ती है। उनको अपनी मेहनत का सही दाम मिलता है और उन वस्तुओं की डिमांड भी बढ़ती है। साथ साथ खरीदने वालों को भी विश्वास हो जाता है कि वो एक जेन्युइन चीज खरीद रहे हैं।
ओह, वैसे नानी मुझे एक आइडिया आया है।
अरे वाह छोटू, तेरे को आइडिया?
यस नानी, अगले महीने फॉरेन से मेरे कुछ दोस्त आ रहे हैं। क्यों ना मैं उन्हें हमारे देश के कुछ सुंदर जीआई प्रोडक्ट्स गिफ्ट में दूं?
ये तो बहुत ही अच्छा आइडिया है छोटू। उन्हें ये चीजें जरूर पसंद आएंगी और हमारे देश की कला का नाम भी होगा।
So after this video, you have already understood or got basic idea that is GI is given to products which are originating from a specific geographical origin. Also, this rights given to or tag given to products which having special qualities based on their environmental condition and the local labor skills. Example is Mahabaleshwar strawberry, then this Shorai painting from Jharkhand, then Ambemor rice, Paithani sadi, Bagh prints, Kolhapuri jaggery, Kolhapuri chappal, Darjeeling tea. Darjeeling tea is the first registered GI, and in India there is more than 300 registered GI till now. Makrana marble, the marble which used for the making of Taj Mahal is from the place name is Makrana, and that is a famous from Rajasthan. So then Ratlami Sev, Nasik grapes, Jalgaon banana, Ratnagiri or Konkan hapus, Puneri pagdi. These all comes under geographical indication. Next is trade secrets. Trade secret is a practice or process of company to not disclose their functioning formulation of any specific product to anyone outside their company or in within the core outside that core group. Example is recipe of Coca-Cola. Coca-Cola has not disclosed the recipe of Coca-Cola to anyone, so they are enjoying monopoly of that product, and no one is able to match same taste as Coca-Cola. Other example is Big Mac sauce, KFC, then WD-40. All are using Google search platform. Why we are preferring Google? Many are preferring because it's fast result and number accuracy and fast results, more number of results. The algorithm on which it is based, they have kept as a trade secret. So due to that, they are enjoying their rights. So what are the validity and terms for these all IP rights? For patents, it is 20 years term. And there is no concept like global patent or international patent. If you want to or make business in particular 4, 5 or number of countries, you require to file patent in that specific countries. Next, IP is design. The term for design patents is 15 years. For trademarks, term is 10 years and you can renew after 10 years for next further more years. Similarly, for GI, term is 10 years initially, then you can renew that after 10 years to next further more years based on the conditions. In copyright slides, I have already mentioned the term or validity is lifetime of author plus 60 years. Now, who can apply for these IP rights? Any single person or legal person, legal representative can file for this all IP rights except GI. For GI, that is geographical indication. The person who can file is the firm, a partnership, small entity, or corporate body, or group of villages. They can come together and file for this geographical indication. These all IP rights. All IP rights are in territorial in nature. So, if you are getting patents in India, the validity or the you can enjoy that rights in the border of India only. Now, what is the patent filing and application process? Which forms required in patents? So, Form 1, Form 2, Form 3, Form 5, and Form 18. These 5 forms are the important forms in the case of patents. So, not only important, these 5 are the mandatory one. You require to file these all 5, then only your process will start. So, Form 1 is details regarding the application and applicant. So title of the invention, then applicant, inventor, address, communication address, that's it. Form 2 is the main complete specification or disclosure of invention. That is the title, background, drawings, and description about your invention, the best method of explaining your invention, the abstract, and claims. This all comes under Form 2. Form 3 is details of foreign filing. If you are filing in India and other countries also, so you require to give details that in Form 3. Form 5 is for declaration of inventorship. And Form 18 is for request for examination. Without this request for examination, that is the RQ, Form 18, your examination process will not start. The standard time is 48 months from the date of priority to file this Form 18. But it is more suggested that you should file as soon as possible after filing your patent application. So the examination will process start soon. These are the general fee structure regarding patent filing. If you are filing as a natural person or educational institute, fees is around 5,600. It is based on number of pages and number of claims. If your number of pages is going more than 30 pages and claims going more than 10, the fees may vary. And if you are filing as an other than natural person, as that is example is company, so in that case the fees for company or other than natural person is around 28,000, but it's also depends on number of pages and number of claims. For exact fee structure, you can refer first schedule of patents rule and which may published in 2000 patents rule 2003 as amended for more details. What are the filing procedures? There is two mode of filing procedure, that is online mode and offline mode. In offline mode, you can submit hard copy to nearest patent office, and after submitting that, you will get the receipt of your submitted documents and as a patent application number, and you can continue that process further also. Other mode is of online mode. In online mode, you can file your application by ongoing ipindia.nic.in. There is one portal for patent filing. Just by logging on that, you can proceed your online filing from your phone, your laptop, or your home also. And for online filing, I think there is some fee discount also given by government. Government is also promoting for online filing, and that's the reason they have given some discount in fee structure. So before starting session, sir was asking for the speedy process. So government comes with some new types of filing, that is a expedited examination. If you are filing as a under expedited examination, your process of examination and granting that goes for can complete within 2 to 3 years. For the criteria for filing this expedited examination is you should be a startup, a small entity, or any one of the applicants. One of the applicant is female, then also you can get the benefit of this expedited examination. Or any if you comes under any department of government, or you are filing as ISA or IPA in international, as India as a searching authority, then also you can comes under this expedited examination. So what is patent application processing? There are three modes, that is PCT, then conventional mode and ordinary mode. As Indians all are filing in India only, we assume that we are filing in India, then you are filing in there is two options, that is provisional specification and complete specification. If you are in process of completing your research, you have done your research in 80 or 90%, the only 10-20% is remaining. So in that case, to get a priority, earliest priority, you can file as a provisional application. Once you filed a provisional application, you get a 12 months time to submit complete specification. In 12 months, you can complete that 10 or 20% invention and file remaining complete as a complete specification. So after filing complete specification, it goes to publication. All application which is filed in a patent office are going to publish within 18 months. Once it goes to publication, it goes published in Gazette of India, Patent Office Gazette. Then based on that subject matter, means if it is belongs to mechanical, chemical, chemistry, physics, biomedical, biochemistry, civil, chemistry, or all the other branches, based on that, it goes to that group of examination. Then it sends to that specialized examiner who having same branch degree or specialized in that subject matter. Then that examiner will start here. It goes for examination. In examination, it goes for formal examination and technical examination. Formal examination is that is number of pages, fees, the format of your complete specification, drawings, and all that details. In technical examination, In technical examination, the examiner will read your invention, then understand that invention with regarding to claims and drawings. Based on that, he will start searching similar subject matter or publication, earlier publication. He'll start for searching citation in worldwide databases. In patent office, examiner having the access of worldwide databases. So on that data, from that databases, he will search some citation. Also check about novelty and inventive step with respect to that citation. And based on that, he will prepare his report as a first examination report. As your first examination report done, it sends to applicant. Within 6 months, applicant has to reply. And once he replied, again examiner will re-examine as a subsequent examination report, which is called as a hearing notice. In hearing, applicant has to explain and give explanation about the remaining pending objection, technical objection. So based on your reply on hearing and at the time of hearing, controller can take decision. Here first examination report, then within 6 months, applicants required to reply to first examination report. Then again, examiner will re-examine that or checks the objection which are pending. Based on that, hearing is scheduled, and after the reply to hearing, the controller can take his decision as a grant or refusal. So this is also one type process where you are filing for patent, then it goes for screening and classification. So if your invention comes under atomic energy, is sent to atomic energy department for their clarification or response. Also, if your invention comes under defense purpose, then it sends to DRDO. After clearance from these two departments, it goes for publication. Once it's published, it goes to specialized branch examiner. So this example is showing, this is Apple laptop, MacBook, which having multiple IPs in it. That is, the logo comes under trademark. The design of MacBook or Apple laptop, it comes under design of patent. Then LED or LCD display of this MacBook comes under patent, and the manual, user manual of this product comes under copyright. So in a single product, they have taken multiple IP rights. These are some of the examples. This Mona Lisa painting comes under copyright. Then this sculpture comes under copyright and design. This Apple products comes under patents, design, trademarks, copyright, all the IPs, all 4 IPs. Then this Coca-Cola bottle having design patent, then recipe comes under trade secret, then the logo comes under trademark, and this distillery is an example of trademark. So thank you everyone. Thank you Village College Rasaini. Thank you Sir Patil sir. Thank you Ridan Pranali. Thank you everyone who have received listened my webinar. If anyone having any doubts, you can ask.
Any questions, please? Students, questions here? Prasad sir, over to you. Any question?
Well, a very comprehensive presentation. I think you can share your PPTs with us.
Okay.
And then second thing is that you said if the patent is related to atomic energy or defense, it goes to that agencies, for scrutiny.
Yeah.
But suppose you file a patent in consultation or in collaboration with DRDO.
Okay.
Then what happens?
If patent file triggered, if you're at that time, it is going to check that is that comes under the atomic energy matter or it's related to other field. The applicant or a collaboration with DRDO is okay, or atomic energy is okay, but the subject matter of that invention is really related to atomic energy only, or it's a general purpose only. So based on that, it is a decision will taken. And if examiner or controller thinks that it's related to atomic energy only, then on again clarification from atomic energy or DRDO is required. If they give clearance that this is for general purpose only, you can proceed, then only we'll proceed that application.
Suppose there is a joint project with DRDO lab, because there
Okay.
are plenty of DRDO labs, you know. So
Okay.
suppose it is related to naval, or it is related to aerospace, or whatever it may be.
Okay.
And a student works there for his project, right?
Okay.
So project, as you rightly pointed out, is also some sort of a intellectual property. And can we patent that, which the work that the student has carried in collaboration with the DRDO or other labs?
Sir, based on that subject matter only, we'll take decision. If we
You see,
think,
the DRDOs,
yes, DRDO.
DRDOs will not give anything because they get finance from Government of India, you know.
Yeah.
So they have their mandate. What is the project? Where is this application, you know? So normally that project they gave a part of it is connected to that. So I was
Okay.
just trying to, if you have got your experience of such projects in conservation with say DRDO, as you said, either I can submit it individually, or
Okay.
by a group of people, or by a group of people from an institute with other defense labs or atomic energy.
But anyway, we require the clarification from DRDO. If,
Which DRDO? Suppose there are 20 DRDOs. So
Okay.
some are related to some missiles, some are related to naval materials. So suppose we work with naval materials lab, which is in Mumbai.
Okay.
So
They have their specialized division which are scrutinizing this part. They have taken kept one special department. So we are sending to them only, and that one office is taking the details from their other offices or the different branches. And based on that, they are responding to patent office. Like this belongs to DRDO or related to defense or not related to defense.
another thing, you know, as for a students, you know, they have to appear in exams. They have got course loads and things like that, you know.
Okay.
So suddenly, you know, I mean, I think if the idea is connected with their project work, that is well and good, because it will be a win-win situation for the student and his performance also.
Okay.
So, for example, if he is working in a project, if we maximize that more projects are related from industries,
Okay.
related to industrial problems, because, you know, then you find somebody who recognizes your contribution, and you know, you can either patent it or you can get employment in that company. That also is some sort of a payment that you get, you know, by virtue of that. Second thing is, after this work is done, you publish by way of research papers in some journals. Now I have to ask you that there are many foreign journals, Elsevier and things like that. If I send it for publications, then I cannot read my own paper. I cannot take a print out of that, because if I want to print out, I will have to pay $20, $30, $50, you know. Whereas suppose Indian journals are there. Have you made any provisions in Indian journals that if I publish a paper in Indian journal, if somebody wants to read there, he can also have some sort of a payment thing for that, so that at least we can have some financial benefit out of that?
Actually, sir, your question is related to journal publication and that, but we are actually dealing related to patents and design only.
But you said that one part of the patent is copyright.
Yeah.
So
It's
the
part of
patent can
IP.
also come under copyright, you know.
Yeah, it comes under copyright, but if you are saying that in India should publish their Indian publications, so that's not comes under patent office or any IP office. You require to file for that. That is a different procedure. but to get published in special journals that not belongs to patent office or any IP office.
I'm trying to have a holistic picture for this whole nation, I mean, after all, the purpose of objective of patent is, for the national benefit.
Yes,
So
sir.
we have to think in a holistic way.
But sir, as per policies and all the matters, so as government have made some policies and structures, so we can't interfere immediately. So I can't want to comment on.
No, I don't know. At your level, you cannot do that. But I'm
Yeah.
just asking that. I mean,
Sir,
to
you
whosoever
can-
may be the policy makers.
Sir, you can send such a suggestion to IP India nic.in. There is one suggestion box. You can send your suggestion. So if they found better or any appropriate suggestion from you, they can implement that.
So who is the patent officer to whom we can make some suggestions?
And IP India nic.in, you will get one option. There is one provision that you can send suggestion or there is a contact details. So on that you can send your suggestion.
Second thing is that, now there are UG and PG and PhD courses, in patent. And
Okay.
if I recollect vaguely, IIT Bombay itself gives some program, which is a course program, which is certificate program.
Okay.
So, like you have competed in some competitive examinations. So did you take any courses, UG, PG courses in patent and things like that? And what are the subjects that are taught in that?
Actually, for patent examination, it should require a technical knowledge initially. So all who are working in patent office, they are all having from science background and have almost all are engineers on. And having specialized, they have cleared the technical exam regarding that subject. So this is the main criteria. And about as you are asking for the IP degrees, there are it is as per policy or recruitment rules they are recruiting. So that is not mandatory one.
No, what I'm saying is, suppose one engineer from my college, he wants to take some diploma in intellectual property rights from a recognized university.
Okay.
So what are his job prospects in your patent office?
In patent office, he can. There are some regular recruitments for patent examiner or controllers for examiner only. So he can file for that, apply for that patent examiner post by clearing that national level exam. He can be chosen as a examiner in patent office. Else, similarly in trademark or other IP offices also having their different recruitment procedures. So based on his interest, he can join that for that offices if he clear that exam. Also, there are some, I think they can file. He can use his knowledge as a expert or as a patent agent. If there is a for patent agent, also there is one exam, that is patent agent exam from patent office only. So authorized agent who are helping for inventor or creator for filing their procedure. So these are the two perspectives there. Also some of the companies are there and you can find on internet also there are some options available.
So you went through those procedures to become a gazetted officer in the government, Maharashtra government, in patent office.
It is central government office and we joined this office after clearing the national level entrance exam, technical exam. So, and their further procedure, two different exams was there.
Which are those examinations? Can you just elaborate that? Which are the examinations which our students can appear after their graduation or during their graduation?
It is after graduation only because this required an engineering degree or the master degree in science. So after that degree only, this patent examiner of patents and design. The post name is examiner of patents and design. So this exam is conducted by patent office and in collaboration with different recruiting boards. So this is the only one available option for being joining this patent office.
Okay, thank you very much. thank you very much. It was very informative and you gave a lot of information which I was not aware of. And we'll try to go through that because you put so many facts in just a short time. So it will be very beneficial for us. Thank you very much.
Thank you, sir. Thank you, Pratik. Dr. Patel sir is here, principal of village.
Okay.
Patel sir, over to you. Would you like to speak? Patel sir. Pratik. Okay, so any questions, students? Shall we move towards the end of this program? Thank you, sir, for giving your valuable time. I'd like to thank on behalf of village management who have given us this opportunity to bring this particular program at the success level. And on behalf of management, faculty members, and students, I really thank you, sir. And definitely we will be in touch with you, because we are also looking for patents through our students projects as well as through faculty members. So thank you very much. Thank you for giving your valuable time. Thank you. Over to you. With this, we will conclude this program. Thank you, students, for joining. Thank you all.